This may be the first certification ever of a class of babies. A class of babies have been certified by Judge LaPlante up in New Hampshire in order for him to issue his preliminary injunction today against Trump's birthright citizenship executive order, in which he tried to declare that the 14th Amendment birthright citizenship only applies to mothers or fathers who are legal green card holders or citizens. That's not what the 14th Amendment says. 9 different federal judges have all said the same thing. But in order to get there, based on a ruling by the United States Supreme Court 12 days ago, the 9 different judges, including Judge LaPlante in New Hampshire, have been struggling with how to issue an injunction. Because the Supreme Court said you can't use a nationwide injunction except in some limited circumstances, maybe if a bunch of states join together. But if you have individual plaintiffs, which is what you have in New Hampshire, somebody from Honduras, somebody from Brazil, then you can't do a nationwide injunction unless you do a class action under Rule 23 and then add a preliminary injunction on top. And that's what Judge LaPlante has done. And very, very craftily, very smartly, he solved the Rubik's Cube of this issue. Because the Trump administration has been arguing that each of the parents have different immigration status who want to be the putative class representative. We call that typicality. They say, well, there's no typicality because one of them is a green card holder and one of them is an asylum petition and one of them is an H-1B or application. One of them is unregistered or not documented. None of them are typical. And Judge LaPlante solved the problem by certifying the babies, not the parents. And I cover it all right here on the MeidasTouch Network and Legal AF. I'm always excited about babies. And I'm very excited when the babies, and it may be one of the first times in history, the babies are the class. Let's break it down here on MeidasTouch and Legal AF. 9 different courts have been struggling with this issue. All of them ruled against Donald Trump and found his executive order from back in April to be invalid. How they handled it was about the same. Most of them issued some sort of nationwide injunction. Some of the courts had states as the plaintiffs. Some of them had public interest groups. Some of them had individual mothers, mainly mothers and fathers, as the plaintiffs. And then the Supreme Court pulled the rug out from under them, at least the ones that didn't have the states in front of them, and said, you can't use nationwide injunction, but also suggested there were carve-outs. You can try class action. Rule 23 of the Federal Rules of Civil Procedure, know it well. You can try that method. And if they fit the elements of Rule 23, boom, you can both declare the executive order unconstitutional and you can do something about it by issuing an injunction. Okay, so then all of these groups scrambled back to their respective courts and reconfigured their complaints as class actions. The Ninth Circuit Court of Appeals, where one of the cases is pending from Judge Coffiner up in Washington, wants further briefing about it. Judge Boardman in Maryland wants further briefing in her trial court level this week. And then she's going to make a decision that's going to be right on top of this one. Very, very carbon copy. She's going to certify a class some way and issue an injunction. But the first one out of the box and protecting the babies is Judge LaPlante. How did he do it? Well, I'm going to read to you from his order. It's very short. But the way he got around this problem, which I think will also inform Judge Boardman in Maryland, is that he focused on the babies, not on the parents. He focused on the babies because they all have something in common. They're all typical. What are their typical features? They're babies born since February the 20th. I guess that's the date of the executive order, and whose citizenship is in jeopardy. Very smart, because that's what they all have in common. Their parents may have come from different places, different immigration status, but that doesn't matter. The babies are all about to lose that precious gift of citizenship, which the judge found is irreparable harm. At the hearing, he said, I don't find the Trump administration's arguments to be frivolous, meaning bad faith, but I don't find them to be persuasive either. He said, at the end of the day, this is not a close call. None of the judges have found this a close call, that a president can't change a constitutional amendment or provision by executive order. Rock, paper, scissors, executive orders don't beat amendments. You can't interpret your way through an amendment or a change, if you will, of a part of our Constitution. You want to do that? Then you're going to have to float an amendment, get 2/3 of the states to support it, and then we're talking. and then have a go through and get a supermajority in the House and the Senate. But you can't just do it on the cheap, free riding, freeloading by just issuing an executive order. That's what every judge has said about it. So let me read to you from Judge LaPlante, who I've been talking about. And here is his order. And I'm going to post this on Legal AF Substack as well. And this is after a hearing that he held on Thursday. After careful consideration of the parties' submissions, the court grants petitioner's motion for a class-wide preliminary injunction. Now, the Trump administration likes to call that, they're doing a nationwide injunction, which the Supreme Court said they couldn't do. It's not what the Supreme Court said. That's what you interpreted. That's what you want, leaving out words. That's what you willfully, blindly want to believe that's what the Supreme Court said. What the Supreme Court said, if you're going to do something nationwide, you're going to have to do it by class action plus preliminary injunction. That's exactly what we have here. The court hereby finds, Judge LaPlante ruled, the court hereby finds that the class petitioners have demonstrated a likelihood of success on the merits, meaning they're going to win on their interpretation of the law as it relates to the 14th Amendment. The class petitioners are likely to suffer irreparable harm if the order is not granted. That the potential harm to the class it greatly outweighs the potential harm to the Donald Trump side if the order is granted. And then pursuant to Rule 65A, he's enjoined and restrained from the executive order being implemented on the 27th of July all of the various departments that matter at the Trump administration. Department of State, Secretary of State, Department of Agriculture, Centers for Medicare and Medicaid, etc. This episode of Legal AF is brought to you by Moinkbox. Did you know 4 companies control over 80% of the U.S. meat industry, and that the largest share of U.S. pork is now controlled by China? These meat giants use mobster-like tactics to crush American family farms, flooding our food supply with sketchy additives and low-quality meat. So what can you do about it? Here's where Moink comes in. Featured on Shark Tank, Moink is standing up for family farms and your food security. Their meat comes from animals raised outdoors, like nature intended. Their farmers get an honest day's pay, and Moink delivers straight to your doorstep at a price you can actually afford. This is real American meat, born, raised, and harvested right here in the USA. Moink is helping save rural America. I love it, and you will too. Join the Moink movement today, support American family farms, and join the, wait for it, Moink movement today at moinkbox.com/legalaf right now and get free bacon for a year. That's 1 year of the best bacon you'll ever taste, but only for a limited time. Spelled MOINK. box.com/legalaf. That's moinkbox.com/legalaf. And he said that there's only a nominal bond of $1 that has to be posted. There was a whole big fight among MAGA, like, there needs to be bonds. We need to make the babies pay bonds. And the judge is like, I'm not making a baby pay a bond. So it's $1, and that should be sufficient given the constitutional implications of the executive order. Now, he has stayed this decision because it's a momentous one. I get the rationale, the conservative rationale. He stayed it for 7 days pending an appeal. And by the time this hot take hits MeidasTouch, Donald Trump will have filed his appeal to the First Circuit Court of Appeal, which sits over New Hampshire, Massachusetts, and the rest. And then he'll brief it at the First Circuit. I think that LaPlante is on pretty solid ground here under Rule 23 class certification. I think it's smart to be certifying a class of babies, all similarly impacted based on the February executive order. And the loser of that appeal, the Trump side, will try to take an emergency application up to the United States Supreme Court, which will either handle it over the summer with partial briefing and maybe an oral argument because of the importance of the substance of the issue, the merits of the issue, or they'll say like, not that interested, but we're going to block or not block Judge LaPlante's ruling here. Because we want more time to make a consideration so they can do something called an administrative stay for a very short amount of time. That could happen. Wouldn't be too concerned about that, but that could happen. Eventually, whether it's this summer on this case or early in the fall, the Supreme Court is going to take up this issue and make a ruling. We're just trying to figure out under what format and procedure they're going to do it. In the meantime, the other 8 cases are progressing. Boardman is about to rule this week. I think she's going to follow LaPlante's view in Maryland. She's going to certify a class. It may be slightly different, and she's going to issue an injunction, nationwide injunction. Judge Sorokin up in Massachusetts has a injunction in favor of 29 states. So it's sort of already been enjoined in the blue states, if you will. And he's able to do a nationwide injunction under our interpretation of the Supreme Court precedent. And then you got Judge Coffenor, who was the first one to issue the injunction on 5 days into the administration. The Ninth Circuit in California has asked for more briefing about the impact of the Supreme Court decision. We call that case CASA Incorporated. They want more briefing on that. And that's how we're watching the judges kind of struggle with these issues. We know the ultimate arbiter is always the United States Supreme Court. The problem for justice and the rule of law has not been the federal judges at the trial court level or the first level appeal. It's been the United States Supreme Court. The trial judges and the appellate courts who look at these issues across the spectrum of bipartisanship, they rule against Donald Trump 90% of the time. The problem is he's winning 70% of the time or more at the United States Supreme Court in numbers that we were not given that credit for, or that deference when Joe Biden was in office. It's certainly going in the favor of Donald Trump. So we'll follow it. But good news here. Can't always be the Grim Reaper on law and politics. Got to bring the good news and the blueprint for good news here on MeidasTouch Network. So in the meantime, I'm Michael Popok, Legal AF. Follow the Legal AF YouTube channel. Come on over there, hit the free subscribe button. MeidasTouch, hit the subscribe button as well. We don't have a paywall. We don't have outside investors. This is it. Just hit the subscribe buttons. And then, of course, I've got a brand new podcast every Tuesday night. Join me there at The Intersection. That's what it's called, on Tuesdays at 8 p.m. Eastern Time on YouTube. And then wherever you can download your podcast from, on Spotify, Apple, and the rest. Come on over there, download that, listen to that, leave a 5-star review, leave a comment. It helps me. And then come over to The Intersection. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.